Hey, this is Rob Ryder, and it's Wednesday, March 23rd, 2022. And it's a big day today because we're going to talk about patriotic pastors, our Romans chapter 13 rulers. It's written in the book. We'll take a look at it. And the reason that's important is the people that the pastors rule are the judges sitting in courtrooms whose rules are canons. Right? They have these things called judicial canons, which is an ecclesiastic rule. And pastors, if you didn't know this, if you think the only place that there's, any kind of persecution is overseas, I can tell you it happens right down the street from your church in the courthouse, where liars, cheaters, and thieves take advantage of their brother on a daily basis because they're a professional. They have license to lie, cheat, and steal. So they do. And the only ones that can keep them in line are the rulers, which should be the pastors, putting a thumb on the judges to make sure the esquires sitting in the courtroom don't, unjustly persecute their brother. What a heck of a system. So, here's an example of minister, right? Ecclesiastic law, one ordained by some church to preach the gospel. Well, that could be important in a little bit. Let's see how that fits into what we're talking about. Okay, so give me just a second. I'll pull a few things up and we'll go through them. And part of what we're going to do today is I'm going to try to provide enough evidence to a pastor that he would believe, well, hey, they're talking about me in Romans chapter 13. Okay, now what do I do with this, or how do I do it? And try to show a real world example of where you could really help out your fellow man by being involved with what happens down at the courthouse. So let's take a look at some of these things. All right, hang on just a second. And so if you know a patriotic pastor, have them watch this video, and let's go take a look at what Romans chapter 13 says. Now I'm using the King James Version because that's the version that was, it's the English common law. But to, properly read the King James Version of the Bible, to understand what the words meant when they wrote it, you would have to have King James's dictionary, because it's the King's English. And they weren't using the same definitions of words in the 15th century as, maybe it'd be the 16th century, as we're using today. But nevertheless, right, this is what it says. So let every soul be subject to the higher powers, for there is no power but of God. The powers that are, or that be, are ordained of God. There's that word ordained. Whosoever therefore resisteth the power, resist the ordinance of God, and they that resist shall receive to themselves damnation. For rulers are not a terror to good works, but to evil. Wilt thou then not be afraid of the power? Do that which is good, and thou shalt have praise of the same. Well, that's what we're going to do. We have no fear of the power, because we're not doing evil. Evil has fear of the power. For he is a minister of God. It can't be any clearer. He who, the ruler, is a minister of God, to thee for good. But if thou do that which is evil, be afraid. For he beareth not the sword, military, in vain. For he is a minister of God. There it is again. He is the minister of God, a revenger to execute wrath upon him that doeth evil. Instead of just complaining about it at the pulpit, you can do something about it. Wherefore ye must needs be subject, not only for wrath, but also conscience sake. For this cause may ye pay ye tribute also, for they are God's ministers, attending continually upon this very thing. Render therefore to all their dues, tribute to whom tribute is due, custom to whom custom, fear to whom fear, and honor to whom honor. Owe no man anything, but to love one another, for he that loveth another hath fulfilled the law. For this thou shalt not commit adultery. Now this is to fulfill the law, right? Hath fulfilled the law. For this thou shalt not commit adultery. Thou shalt not kill. Thou shalt not steal. Thou shalt not bear false witness. Thou shalt not covet. And if there be any other commandment, it is briefly comprehended in the saying, namely, that thou shalt love thy neighbor as thyself. Well, pastors, that isn't what happens in the courtroom. None of those things. I mean, all of these laws are broken. And the judge lets it happen. And that's where you come in, because you rule the judge. Love worketh no ill to his neighbor, therefore, love is the fulfilling of the law. And that knowing the time, that now is not high time to awake out of sleep, for now is our salvation nearer than we believed. The night is far spent, the day is at hand. Let us therefore cast off the works of darkness, and let us put on the armor of light. Now they're talking to us. We're no longer talking about the pastors. They're talking about the rest of us. Let's walk honestly, as in the day, not in rioting and drunkenness. Sorry about that. So, where were we? 13. Let us walk honestly, as in the day, not in rioting and drunkenness, not in chambering and wantonness, not in strife and envy. But put ye on Lord Jesus Christ, and make not provision for the flesh to fulfill the lust thereof. Well, if you're putting on the Lord Jesus Christ, then you're coming in his name. And we're going to come in his name to the ministers of the Lord, which are the shepherds of the flock, the sheep, to protect them from the wolves in the courtroom. Right? Because whatever happens in the real world, whether it's a foreclosure or taxes or whatever, eventually it ends up in a courtroom. And it's the judges that are making the decisions. All I'm saying is it's the Romans 13 ruler that rules the judges. And we're going to show you how that works here in just a second. Okay, so let's talk about this connection between the patriotic pastor and the military, which is the Gold Fringed Flag. And don't let anybody tell you that, well, the church doesn't have a Gold Fringed Flag. Sure they do. Right, there's one right there. Of course, this isn't a Catholic church, and so there's the Vatican flag. But there's a Gold Fringed Flag flying in a church. And, it doesn't really matter what your denomination is. If it's a mainline Protestant denomination, Catholics or the Orthodox, they all have Gold Fringed flags. Okay, well, what does that mean exactly? Well, as it turns out, hey, there's an Army regulation on flags. And, so it's Army Regulation AR, so AR 840-10, right? Flags got on streamers, tabards, and so forth and so on. And it's, all quite interesting, but if you go to chapter 2, to start there, right? Flag of the United States. So what you'll find out by reading this is, when you see the flag of the United States, like on a flagpole outside, if that building isn't a school, then it's somehow connected to the military. Because there's very few places that a flag of the United States can be displayed publicly. Privately, you can hang it on your house, you can do whatever you want. But publicly, for a public entity to display a Gold Fringed Flag takes a certain license to do. Right? So in this chapter 2, Flags of the United States, it gives all these different sizes, the flags of the United States. Right? And we go down far enough. The national flag listed below are for indoor display and for use in ceremonies and parades. Right? For this purpose, the flag of the United States will be of rayon banner cloth, trimmed on 3 sides with gold and yellow fringe. And then it goes on to say where it's authorized to be displayed. And if you were to read these, you would say, well, these all have something to do with the military, like a military courtroom. Right? Well, one of the places it has something to do with is a chapel. And, so now the question is, well, how did the church ever get a gold fringed flag from the military? How did they ever get, enlisted into the army, to the armed forces? Well, they didn't enlist, they got a commission. And I've shown this in a number of videos before. And I'm going to want to show just a few pieces of it today. But in this little handbook here called the Handbook of the National Catholic War Council, which you can download online, and I suggest you do, even if you're not a Catholic pastor. The Catholics wrote a very good handbook on why you have this authority. Now, the Protestant churches have their own entity, and I'm going to show you that in a second, but they were all given. So what happened was in 1917, after Congress declared war, Wilson issued a proclamation, and then the churches answered. And what they did is the churches created these civil organizations. So it's really not the church, it's a civil organization created by the church. And that organization was given a military commission from the War Department. It didn't come from Congress, right? This commission came from the War Department, and so that commission still exists because World War I never ended. They acted like they were going to end it. They started doing a peace treaty, but it was never ratified. It's like everything else. It's not completely done. Just the same as the Civil War isn't done. There was only ever an armistice, which is not a peace treaty. And Lincoln declared martial law in 1863, September 15th, 1863, over all the United States, and it's never been rescinded. And according to the Lieber Code, which was also published in 1863, which is the governance of the armies of the United States in the field, it says in the second article that once martial law has been declared, it doesn't end until there's a proclamation or a peace treaty. Well, those things didn't happen, and so the military is still in charge, and the United States is under martial law military form of government. Now, that isn't what we see that calls itself the Congress and your governor and all these other things. That what we see that we are told is the government is a democracy. And that democracy is the United States of America, which is not the United States. In the United States, you're supposed to have a Republican form of government. There's nothing in the Constitution whatsoever about a democracy. But a democracy is what King George III's successors' jurisdiction is, which is the United States of America, which is just a private society in the United States. But it's not the United States. And we've been shanghaied into this private jurisdiction by esquires through acts of bad faith. And the way to get out of it is for the rulers under Romans chapter 13 to go to the judges of these King George's jurisdiction and tell them they have to stop. Well, that's, sounds easy enough. Just need somebody to do it. Well, thankfully, because I was helping somebody in jail whose sister's on the outside trying to help him, and she's has a good relationship with her pastor at church, her pastors agreed to fill out a Army sworn statement form. So before we look at the handbook, let's look at that sworn statement form. I mean, this is an example of a positive thing that can be done by a pastor. And I've shown this form numerous times on the videos, right? It's called the sworn statement form. It shows these routine uses, what it could be used for. Disclosed to federal, state, local, foreign government, law enforcement agencies, prosecutors, courts, child protective services, victims, witnesses, Department of Veterans Affairs, Office of Personnel Management. All these things are different government agencies, right? And um, because this is a form in a military jurisdiction, when you get to the end where the affidavit is, first you have your statement, and now you're going to swear to your statement. So you're not submitting an affidavit, you're submitting a sworn statement that has an affidavit. But when you go to court today, they try to make it sound like you're submitting an affidavit. And by definition, an affidavit is an oath rendered to writing. And an oath can't be challenged, but evidence can. And we're trying to put evidence in, right? So a sworn statement is evidence. In fact, because it's done this way with two witnesses and the person administering the oath, this would become foolproof evidence, also known as self-authenticating evidence, and it needs nothing else to prove that it is what it says it is by the rules of evidence, right? So it's more than just having a notary signature on your document. Now, the reason you can't use a notary in this case, in my opinion, is a notary doesn't have any jurisdiction or any authority in a military jurisdiction. But a preacher does, because you got a gold fringed flag. All right, so the person making the statement is going to sign here. The preacher is going to sign here. We're going to have two witnesses. And now you can submit this form to any of the places that were listed up here, and it will be seen as evidence, foolproof evidence, coming from the military jurisdiction, from the gold fringed flag jurisdiction. Well, guess what's in courtrooms? Gold fringed flags. You know where else there's gold fringed flags? The county building's got one. Your township supervisor has one. The American Legion has one. All sorts of places have them, but they're not using them. Right? Because you have to be somehow tied to the entity that has the gold fringed flag, because they're acting as your agent. And that's really what this book would tell you about right here, is that the whole reason that the military did this is they turned these church civil organizations into cooperating agents between the people of the parish or the church or the congregation and the other wartime agencies, which is anybody that has a gold fringed flag. Right? They didn't tell you this. We've been under martial law since 1863. You're just going to have to get over it. But because of that, well, what does that mean today? Well, what it means is, we're just going to the wrong people to try to get relief. We should be going to the rulers to go talk to the judges about why we're in court or whatever the other reasons are. So hang on just a second. And, not trying to make anybody an expert on this book. I'm far from being one. But what I can tell you is that the first part of this handbook is like a model organization set up from the top down, right? From national headquarters down through the diocese, because it's a Catholic church, and then down to the parishes. But that the real power in this whole thing was down in the parishes, which was to create its own parish war council that would have members of the laity as the, sitting on the board. And so, basically, the laity would be in charge. It's just being done through the parish. So, okay, so if you have that, what are they supposed to do? And this is where it gets good, because in Chapter 4, it talks about the governmental and supplemental agencies and war work. So let me just read a little bit, right? The war has mobilized every resource of the American nation for one purpose of bringing victory to the ideals of the Allied world. No individual in this great land of ours can stand without a circle of war workers. From the moment that the state of war was declared between this country and Germany, the watchword turned from preparedness to cooperation. 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 individual cooperation has been accepted by the government wherever it was found to be valuable, but it is the cooperation of organized bodies in the land which is best suited for the work the government has outlined as its support. Right? You got to have. Right? So basically, the government doesn't want to deal with individuals, it wants to deal with organizations. And the organizations will deal with the individuals. So, right? But it wasn't just the Catholic Church. Now, here's the other ones. The different Protestant denominations have organized for war purposes under the title the General Wartime Commission of the Federal Churches of Christ in America. The Jews, Orthodox Reformed, under the Jewish Welfare Board of the United States Army and Navy, and the National Organization for War Work in the Catholic Church is the National War Council. All of these are asked to cooperate with governmental agencies on war work. And the war is still going on. The problem of the government are, in many cases, common to all, and only a common understanding can contribute to national well-being. It is our duty to manifest a spirit of cooperation in national and local problems, and it is our duty to cooperate with all the agencies of national war work that the government has established. So if they have a gold fringed flag, the preacher can pick up the phone because you guys are in the same jurisdiction. The difference is you're a minister of God. Right? You represent him. It'd be impossible to get a complete description of the government agencies, but a description of the principal ones will be sufficient to enable each stake unit National Catholic War Council. So let's find out who they get to, who the parish council / the patriotic pastor gets to deal with. Right? The Department of the Treasury. So the name Department of the Treasury is a wartime agency for the Treasury Department. When you're dealing with something called the Department of the Treasury, just because by it using that style of name is an indication that it's a wartime agency, which it is. And these are all the things it does for the fighting man, which basically they're supposed to keep track of the fact that you served in the military and that you have these privileges coming to you. Right? And if you're not getting your privileges, you're supposed to go to the church to have the pastor pick up the phone and find out why you're not getting your privileges. And there is a couple other biggies in here. Let's see. The work of the war camp community is vital. Preservation of normal social relationship between peoples and men and training is an essential part of the military program. The war camp community services accomplishes preservation. The commission discouraged sentimentality towards soldiers and sailors, but they encourage and attract a helpful diversion. These are the things which American municipalities owe to the nation's fighting men. So basically, things owed to you by the municipality that doesn't want to give it to you. This organization is the agent to help a veteran get whatever it is they're not getting because we can't get the municipalities, which are, also under the Gold Fringed Flag, to give us what's ours. So I'm talking about things like, every county is supposed to have a veterans office and how your veterans papers are supposed to be properly recorded and so forth and so on, and it goes on and on and on, and none of this shit's happening. But it wasn't just them. You got the Department of Labor. They got the military here, right? Department of Agriculture. These are the different agencies that Department of War and Navy, that because the pastor has a gold fringed flag, if you have an entity set up, well, then they can communicate directly with these places within the jurisdiction of the wartime government. Not under Nancy Pelosi or Chuck Schumer or Biden or any of these people. That's the democracy. It has nothing to do with the republic. It's not a Republican form of government. What we're going to do is find what the written law says and say, hey, they're not doing what the written law says, so what do we do? I'm saying we're supposed to be taking it to our patriotic pastors or the congregation's wartime council or, whatever it ends up looking at. But today is baby steps, just to show that it exists. Okie doke. So, hey, let's look at a practical example of where this could come into play. And we'll start by looking at the Constitution of the United States, which is not the Constitution of the United States of America. It's the Constitution of the United States. Maybe the Constitution for the United States of America, King George III's jurisdiction, but it's the Constitution of the United States. And in the 6th article of that Constitution, after we get past the part about all debts, it says, this Constitution, laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. Pretty self-explanatory. The common law of the United States is the laws of the United States. Okay, and then the senators and representatives before mentioned, and the members of the several state legislatures, and all, ALL, all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall ever be required as a qualification to any office of public trust under the United States. Okay, well, pastors, I'm here to tell you there's no senator, representative, member of the several state legislatures, or any executive or judicial officer of the United States or the several states that's taken the oath that we're about to look at, which is the oath that satisfies the 6th article of the Constitution. And the reason I know that it is because it was written into the law that way. Right? So there's the Constitution. And just right after it was ratified, the very first law passed after the ratification of the Constitution is this law here, which is commonly called 1 Stat 23. But its name is an act to regulate the time and manner of administering certain oaths, in which it said that the oath or affirmation required by the 6th article of the Constitution, that'd be the thing we just read, right? Constitution of the United States, well, that's what we just read, shall be administered in the following form, to wit, I, A.B., that would be state your name, do solemnly swear or affirm that I will support the Constitution of the United States, period. So that oath right there, right, from quote, double quote to double quote, is the oath that satisfies the 6th article of the Constitution. Nothing else does. This isn't the oath that's being taken. Not only that, where it says AB, that would be you have to state your name. Well, that would be your full legal name, not a nickname or what you like to call yourself or what you're, depending on what gender you think you are today, you're going to have a different name. No, it's the name that's on your birth record or on a real ID compliant ID, right? And mine would be Robert Allen Retluski, where Robert Allen is my first name, Retluski is my last name, and I have no middle name. Okay, so there you go, right? That's the oath that satisfies the 6th article of the Constitution. If they didn't take this oath, then they have no authority in the United States. And I'm telling you, they haven't taken the oath. Okay, now, that's what I say. Let's go see what they say. The thing is that according to this act, they have to have the proof they took the oath. I don't need to prove they took the oath. They need to prove they took the oath. Right? They have to have a certificate or a record. Hang on just a second. All right, that all officers appointed or hereafter to be appointed under the authority of the United States shall, before they act in their respective office, take the same oath or affirmation which shall be administered by the person or persons who shall be authorized by law to administer such oaths, officers their respective oaths. And such officers shall incur the same penalties in case of failure, as shall be imposed by law, in case of failure, take the respective oath of office. Well, since the time of King Henry VIII, it's been a common law act of treason to knowingly omit taking a loyalty oath. So where they could say it was a mistake, if they don't take it, now it's treason. And if they haven't taken it, even though it was a mistake, according to the 6th article, well, they didn't have any authority until they took the oath, so whatever they did is mute, has no legal value. And this is what happens in court. You have people who don't have any authority pretending to be judges. And then finally, this finishes up the House of Representatives, right? The clerk has to take an oath, and the same with the Senate. And we should go and make sure that they've taken this oath. I, A, B, Secretary of the Senate or Clerk of the House of the United States of America, do solemnly swear or affirm that I will truly, faithfully discharge the duties of my office to the best of my knowledge and abilities. If they don't have that in the office, then they're not the clerk. And, nobody has taken this oath. Now, the 6th article said officers, executive and judicial officers of the United States and the several states, right? And that's what this law says also. But sometime later, we went from having statutes at large to having the United States Code, right? And so in the United States Code in Title IV, subsection 101, oath by members of legislatures and officers, that every member of a state legislature and every executive and judicial officer of a state shall, before he proceeds to execute the duties of his office, take an oath in the following form. To wit, I state your name, you solemnly swear I support the Constitution of the United States. Hey, that's the same oath. Right? It's just been extracted and put in here specifically so that to the state to say, brother, every executive and judicial officer of the state shall take this oath before he proceeds to execute the duties of his office. If he hasn't done it, then he's not a judge or he's not a police officer or whatever. Right? Because this goes all the way down to the dog catcher. Right? If you want to hold an office in your state's government, you first have to take an oath to the federal government, because that's the way she works. And then this goes on to say that such oath may be administered by any person who, by law of the state, is authorized to administer the oath of office, and the person so administered such oath shall cause a record or certificate thereof to be made in the name or in the same manner as by law of the state he is directed to record or certify the oath of office. So the oath taker has to have the proof they took the oath. If they didn't have the proof, then they cannot exercise the duties of the office, which means they can't put you in jail. They can't take your house into foreclosure. Right? They can't charge you for taxes. They can't do anything because they're not the government. They're just pretending. Well, they're doing it anyways. And so the problem is that the rulers aren't going to the people that are supposed to follow the canons to make sure they're following the canons. So let's look at that real quick. Okay, so, for this demonstration, we're going to be looking at things to do with the Ohio judicial system. And so if you went to the supremecourt.ohio.gov, right, supremecourt.ohio.gov, you could find these Ohio rules of court. If you just Google Ohio's rules of court, you can probably get to this same page. And right, so you got like the civil procedure and the criminal procedure and rules for government of the judiciary and judicial conduct and so forth and so on. And we're going to look at a few of these, and I'm going to show you that based on what they say, that there's no reason that a ordained minister can't go to the judge and say, Judge, you got to stop. Right? I order you to stop. Because judges are governed by canons. And we'll see what that means in a second. But the reason this started was I got a call from a veteran who was in, they were going to evaluate him to make sure he was competent to go to court. Right? So whatever that is. Mental health. But he had access to a telephone. So I talked to him a couple times, and then his sister called me. Well, as it turns out, she's a really good go to church on Sunday woman who I had told her, said, look, if you can get your pastor to agree with these things, for the things I've just talked about in this video, I think that he could do a sworn statement form, right? This DA form 2823, and we could put it in based on the things that are going wrong in the court case. Well, he's agreed to do this. So that's by itself is a huge thing. But because he had, I said, well, let me go read these rules closer now about the Ohio system, and that's what we're going to look at. Because I don't even know that we need to do the sworn statement form now. Right after looking again, to say, well, the dude's already the ruler. Or you just need to show him that he has the authority to do it. And that's what I want to do now. So give me just a second. So each of these PDFs we look at, they came from this list here. So like the first one we're going to look at is the rules for the government of the bar. Supreme Court rules for the government of the Bar of Ohio. Right, and well, we don't have time to look at it all. We can see you got the admission to practice law, limited practice of law, all these different things, right? But page 12. So this is induction to the bar. Each applicant accepted for admission to the practice of law in Ohio, it doesn't say state of Ohio, it just says Ohio, shall take the following oath of office. I state your name hereby swear or affirm that I will support the Constitution and laws of the United States and the Constitution and the laws of Ohio, and I will abide by the Ohio rules of professional conduct. In my capacity as an attorney and officer of the court, I will conduct myself with dignity and civility, and show respect towards judges, court staff, clients, fellow professionals, and all other persons. I will honestly and faithfully and competently discharge the duties of an attorney at law, so help me God. Well, see, this is that word faithfully in there, right? So if they were to do these things properly, that would be an act of good faith. But if they don't do them properly, well, then it's an act of bad faith. And that's when the church gets to step in, because the church, according to the Supreme Court of the United States, the courts have no jurisdiction in matters of faith. Right? That's the church's jurisdiction. And if we don't call it out for being a matter of bad faith, then they can go ahead and do what they're doing because, no one called them out on it. So this isn't done just by judges. This is to be an attorney, right? Before you can be a judge, you have to be an attorney, or a lawyer is probably the proper term. And they have to have taken this oath. So where's a copy of this oath? We'll get to the, taking an oath to satisfy the Constitution later, but okay, you want to be an attorney, where's this oath at? Well, it looks to me like it should be with the Office of Bar Admissions. And so I've actually asked if they have a copy for them to send me, right? It says the oath for successful bar examination applicant shall be administered by a state or federal judge. In no event shall the oath of office of an applicant occur prior to the bar admission ceremony that the applicant qualified to attend. If the applicant does not attend the bar admission ceremony, an affidavit for administration of the oath in a form prepared by the Office of Bar Administration shall be executed and returned to the Office of Bar Administration or Bar Admissions. So the Office of Bar Admissions must be the keeper of the oaths. And every attorney in Ohio is supposed to have taken one. So you should be able to contact these people, Office of Bar Admissions, and say, you wanted to see somebody's oath to make sure they were who they said they were. Now, they're going to make it all sorts of difficult. I don't even know if they would do it because they're not used to doing anything except what they want to. I'm just saying that their protection is about to be withdrawn and, things could change in a hurry. Okay, so they're supposed to have taken this oath. Hang on a second. Okay, and then just as huge is in here, it had the definition of a judicial officer. And what page is that on? 87. So hang on. Definitions. Judicial officer means any person who is subject to the Code of Judicial Conduct as set forth in the application section of that code. Well, why is that important? Well, in case you forgot, right, the sixth article said that the senators and representatives, before mentioned, members of the several state legislatures, and all ALL executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test shall be required as a qualification of any office of public trust under the United States. Okay, well, that would mean then that whoever these people are here have to have taken the oath to satisfy the sixth article of the Constitution. And since in this case we're talking about state officers, then basically they would have had to have complied with Title IV United States Code, Section 101 and 102, as it says in the sixth article, the Constitution and laws of the United States, which shall be made pursuant thereof, and all treaties made, or shall be made under the authority of the United States, shall be the supreme law of the land, and all judges in every state shall be bound thereby. They don't have a fucking choice. They have to have taken the oath, or they don't have any authority to do anything. Okay, so I said to go look at this Code of Judicial Conduct. Well, let's do that. Ohio Code of Judicial Conduct. Hey, look at these are canons. But, we'll get to that in a second. Here's the application section. Applicability of this code. This code applies to all full-time judges. The application section identifies provisions that do not apply to distinct categories of judges. A judge within the meaning of this code is a lawyer who is authorized to perform judicial functions within a court, including an officer such as a magistrate, court commissioner, or special master. All of them peoples have to have taken an oath to satisfy the sixth article of the Constitution, or they have no constitutional authority in the United States to enforce the laws of the United States or of the state. Yet when you go to court, that's what they're pretending to do. But they haven't taken the oath. But continuing on, right? So this is judicial conduct. So this is, what the judges have to follow. And we now know who we're talking about, who it applies to, and what's the very first canon. A judge shall uphold and promote the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and appearance of impropriety. But what about compliance of the law? A judge shall comply with the law. Okay, well, what does that mean? Well, see the definition of law in the terminology section. Check. So, okay, let's go back to the top and let's click on terminology and see where that takes us. We're looking for the law. Ex parte, fiduciary, impartial. Blah, 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 blah. Hey, here we go. Law encompasses court rules, including this code and the Ohio Rules of Professional Conduct, statutes, constitutional provisions like the sixth article, and decisional law. Well, decisional law would be, I don't know what that'd be exactly. We have to figure that out. But statutes, right, that would be, well, what's written in the laws of your state. Because you can go read the laws of the state and say, well, you people aren't following this stuff. Because they're not. It's just no one's calling them on it. But it encompasses court rules, including this code and the Ohio Rules of Professional Conduct. Okay, so like I mentioned, this kind of got started because I got a call from basically Jerry Potts, and I've talked to his sister since. And, this is the court case going on in Medina, Ohio, right? Medina County, Ohio. And the judge is Christopher Collier. So this Christopher Collier would have to have done the things we've just been talking about for him to be a judge, to judge uh, a violation of Ohio statute. And what they said that he violated is here's the indictment. Right, here's the indictment. Again, this doesn't have any legal value because it's not Gerald R. Potts. It's, whatever his middle name is, Potts. I don't believe state of Ohio is a proper name for the plaintiff. I think it's supposed to be the state of Ohio. But it's supposed to be an indictment, and, they said he violated this Ohio Revised Code Section 2903-11, felonious assault. Right, so they charge him for a felony. Now, apparently what happened, there was a, domestic disturbance between siblings, and one of them got hurt. They had to call an ambulance for a cut, just a couple stitch cut. Wasn't a big deal. But because of that, it's become a felonious assault case. And that wasn't the intention of the person that got hurt at all. And in fact, they didn't call the police; they called an ambulance. But the police showed up, and when the police showed up, they finally coerced somebody into giving them the key to the door to go pull Jerry out. And now that they're in the house, they're going to go ahead and do a search. And all of a sudden, you got 16 other things that had nothing to do with the original reason for being there that have happened. So people started going through your drawers and shit. So it became a big clusterfuck, right? All because of this alleged violation of this Ohio Revised Code. But also notice that the way that this is written, it says this offense is contrary to the form of statute in such case made and provided, and against the peace and dignity of the state of Ohio. So they're not only trying to charge you for a statute violation, they're going to charge you for disturbing the peace. Now, when they start a criminal case, it starts in the lower court. Here it's called the district court. Ohio was called a municipal court. But that's where you first go to court. You get your preliminary arraignment. All these things happen, and if it's a felony, then it's supposed to go to the big court, circuit court, or court of common pleas, or whatever it's called. And that's what's happened to this. Was there were supposed to have been hearings at the lower court, determined that it was going to the higher court, and now it's supposed to be in the higher court. Well, the problem with all that is that if we look at the docket for this case, we go down here at the bottom, this is the indictment file. That's the thing we're just looking at. But there's supposed to be a transcript from the Medina Municipal Court sent with it under this case number, and there's no document. Apparently, there's supposed to be some summons issued by the prosecutor, but there's no document. And it returned, but there's no document. So none of these things happened, and yet the court case is going. Now, how can that be, right? I mean, these things are supposed to have happened first before there could be a court case, and yet none of these happened, and then all these other things have happened. So, including getting sent to the nut house and, held against your will for months at a time because they're going to say now it's a mental issue. So it's really messed up. But what I want to do before I forget, I'm going to go look and see what this section has to say, because this will blow you away. Right? Felonious assault. No person shall knowingly do either of the following: cause serious physical harm to another, or to another's unborn. Well, that would mean anybody who's performing an abortion has violated this section, and it's a felonious assault. Right? It doesn't matter if what the woman thought of it. If you seriously harm another's unborn, it's felonious assault, doctor. And if you're listening, patriotic pastor, there's your jurisdictional law that you could have enforced to stop abortions. Right? cause serious harm to another or to another's unborn. Amen to that. So anyways, knowing that there's these holes in this procedure, right? So this would be like a denial of due process because this is part of the process and there's nothing there. So Jerry's being denied due process by attorneys who had better have taken an oath of office to be an attorney, but now that they're a judge, a judicial officer, they also had to take another oath to satisfy the 6th Article of the Constitution. Or they're not a judge, and they can't enforce the state law, which is what they're saying he violated. Right? But all of this, what's happening then, would be covered under the Ohio Rules of Criminal Procedure. And we're not going to spend too much time on this, but it would start with the fact that there has to be a complaint. And then upon the complaint being issued with the affidavits, they'll determine there's probable cause. And issue a warrant or issue a citation. Or a summons, excuse me. A copy of the complaint shall be attached to summons except when an officer issues a summons in lieu of making an arrest without a warrant, or where an officer issues a summons after arrest without a warrant. So basically, Jerry was arrested at his house. There wasn't any warrant, right? So he would have been under some kind of summons to show up, which is what this is showing. There should have been. Right? Criminal case filed. There's nothing there. Summons and copies issued to sheriff. Well, there's nothing there. Summons returned. Well, there's nothing there. So how did they do what they did if there's nothing there? Yet to be found out. We got arrest upon persons, and we go to arrest without warrant, release after arrest. Right, arrest without warrant. Where a person is arrested without warrant, the arresting officer shall, except as provided in F, bring the arrested person without unnecessary delay before a court having jurisdiction over the offense. Well, that'd be the municipal court. And shall file or cause to be filed a complaint describing the offense of which the person was arrested. Okay? Release after arrest. The officer issuing such summons shall note on the summons the time and place the person appeared, and if the person was arrested without warrant, shall file or cause to be filed a complaint describing the offense. No warrant or alias warrant shall be issued unless the person fails to appear in response to the summons. But again, there was never a summons. It's blank. Right? So how could that be? Okay, then we get a preliminary hearing. This is where it all happens now, because he's got a preliminary hearing in a felony case. In a felony case, the defendant is entitled to a preliminary hearing unless waived in writing. If a defendant waives a preliminary hearing, the judge or magistrate judge forthwith shall order the defendant to be bound over to the court of common pleas. So the judge or magistrate are both, by definition, judicial officers, and both of them would have to have taken the oath to satisfy the 6th Article of the Constitution and have a certificate or record to prove it, or they're not a judge or a magistrate, and they cannot enforce laws of Ohio. Except upon good show and any misdemeanor other than a minor misdemeanor arising out of the same act or transgression involving a felony shall be bound over or transferred with the felony case. Other than a minor misdemeanor. Well, you know what a minor misdemeanor is? Disturbing the peace. Right? So technically, while the felony parts are going over to the big court, the smaller court is keeping the peace and dignity violation. But I don't think everybody knows that. That's what this law is saying is, right? Except other than minor misdemeanor, which is what disturbing the peace is. And, the reason I know that is Rosita had a case some years ago where she had gone to the clerk's office, recorder's office, county recorder, asked a few too many questions, and finally the clerk called the sheriff on her. right? Well, it ended up they were charging her for disturbing the peace, right? They're going to put her in jail for it. But we started looking around, and in Batavia, the next city over from where she lives, they actually had that disturbing the peace is a $25 fine. For you have to pay a fine for $25. Well, how come she's being put in jail? Well, she never paid $25. Now, we couldn't find it for where she was at, but I'm just saying, in the next city over, the same charge would be a $25 fine. So there's something happening still in the lower court that hasn't been cleared up yet, and because you haven't cleared it up, you're in contempt of that court. That's what I think's happening. It really has nothing to do with this bigger court, because according to this, it's never really started. So anyways, so except for good cause shown, right? Other than a minor misdemeanor, and it's like, well, they either need to all go together, or Jerry needs to go back to the little court to get it cleared up. If the defendant does not waive the preliminary hearing, the judge magistrate shall schedule a preliminary hearing within a reasonable time, but in any event, no later than 10 consecutive days following the arrest or service of summons, if the defendant is in custody, and not later than 15 consecutive days following the arrest or service of summons, if the defendant is not in custody. The preliminary hearing shall not be held, however, if the defendant is indicted. Oh, so they acted like they indicted him, so they never had a preliminary hearing. So, Jerry was denied due process. Now, the thing with this indictment is it's not done properly, because when we go to the second page, it's been signed by the prosecutor and the attorney. And there's nowhere, as we'll see, in doing an indictment, where it says anything about the prosecutor and attorney signing an indictment. And another thing is that an indictment is supposed to be endorsed true bill. Not a true bill, just true bill. So this document is simulating a legal process under color of law. It says the jurors of the grand jury of the state of Ohio within and for the body of Medina County. Well, that's no. This is the grand jury of the Court of Common Pleas for Medina County, not the grand jury of the state of Ohio. Right? This is like a foreign jurisdiction. And so that's what I'm saying. See, they've pulled us out of the United States and taken us to the United States of America, King George's jurisdiction, run by esquires. Esquires are crown agents by definition. They're not titles of nobility. That would be a knight. But they're agents of the crown. And they've taken you into a private court system, pretending to be the state court system, acting like they can charge you for a felony. Even though these are not properly cited Ohio state laws, you would think that that's what it is because of how it's written. But this isn't a proper citation for a statute of Ohio. They just act like it. They're just doing what they always do. Okay, so this goes on to say then that with the consent of the defendant and upon showing a good cause, taking into account public interest and prompt disposition of criminal cases, time limits specified in this division may be extended. In other words, they can hold you in jail longer than this 10 consecutive days or whatever before they have a hearing. Well, Jerry's never going to get a preliminary hearing because he was supposed to have been indicted. In the absence of such consent by a defendant, time limits may be extended only as required by law or upon showing that extraordinary circumstances exist and delay is indispensable in the interest of justice. Well, that isn't at all true. Right? Jerry has been held since November of 2020 for something that was just a minor dispute between siblings that they had all hugged and said they were sorry for the next day, but instead it became a fucking federal case, basically. Well, it's at least a felony case. Right? And then in any case in which the defendant is ordered to appear for trial for any offense other than the one charged, the court shall cause a complaint charging such offense to be filed. Okay, well, he's only been charged right, with this felony or with disturbing the peace. Upon the conclusion of the hearing and finding, the court or the clerk of such court shall within 7 days complete all notations of appearance, motions, pleas, findings of criminal docket of the court, and shall transmit a record of the appearance, dockets, entries, together with a copy of the original complaint and affidavits, if any, filed with the complaint, the journal or docket entry for the reasons for the charges or changes in the charge, if any, together with order setting bail and the bail, including such bail deposit, if any, filed to the clerk of the court, which the defendant is to appear. And as we keep showing, well, that never happened. So apparently he's not supposed to be appearing for a felony because it was never, right? The transcript was never sent over. A municipal or county court retains jurisdiction on a felony case following the preliminary hearing or waiver thereof until such time as a transcript of the appearance, docket entries, and other matters required for a transmittal are filed with the clerk of court in which the defendant is to appear. They've not been filed. It'd all be right here. Right? So the lower court still has jurisdiction, because it hasn't been filed in this court. It doesn't matter if the lower court knows it or not, because the upper court didn't file it, they still have jurisdiction. And so this is where, the ruler has to come in and say, hey, boys, you guys are going to have to tighten up here. We can't have this. They talked about grand juries, the indictment and information. And then here, when a defendant makes a written request within 21 days after arraignment, but not more than 7 days before trial or upon court order, the prosecuting attorney shall furnish the defendant with a bill of particulars, setting up specifically the nature of the offense charge and conduct of the defendant alleged to constitute the offense. This is the thing you're supposed to defend yourself against. A bill of particulars may be amended at any time, subject to conditions of justice requires. But again, we can see here that a motion was filed for bill of particulars. In fact, we can view it. If I push the right button. Maybe not. Oh, it says it can't be found. It says it's there, but it can't be found. Go figure. So, this would lead you to believe that this felony case is moving ahead in the Court of Common Pleas in Medina County, Ohio, under a Judge Christopher Collier. But as you can see, it says it's a pending case. And if we were to look at the documents for this case, let me see if I can find one real quick. I think I have one. So actually, the motion was there. I had to go refresh, right? So this is the motion for a bill of particulars that was filed by his attorney, which says, in the Court of Common Pleas, Medina County, Ohio. Well, there is no court named in the Court of Common Pleas. It's just Court of Common Pleas, or it could be the Court of Common Pleas, but it's not in. Right? This is, it's a simulated legal process. It's going to something that really isn't happening. But it was, asking for this bill of particulars. And Sandy, who's Jerry's sister, has asked for it, and they won't give it to her. So this again is why, a ruler should go there and say, give the sister, the man's bill of particulars. Because guess what? Prosecutors got a Gold Fringed Flag. I want to show you something on canons, and I'll be done with this. Hang on a second. So, just to recap, right? Judicial officers, who we've been determined by looking at application, is judges, magistrates. Well, who else did it say? Right? A judge within the meaning of this code is a lawyer who is authorized to perform judicial functions within the court, including an officer such as a magistrate, court commissioner, or special master. All those people are governed by this Ohio Code of Judicial Conduct, which is a code of canons, where it says a judge shall uphold and promote the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and appearance of impropriety, and a judge shall perform all duties of judicial office impartially, competently, and diligently. All canons. And this one about compliance of the law says that we need to see what the definition of a law is in the terminology section, but that a judge shall comply with the law. Well, that's good to know. And let's go look at the terminology section again. Terminology says law. Encompasses court rules according to this code and the Ohio Rules of Professional Conduct, statutes, constitutional provisions, and decisional law. Those are all considered laws. That's what the judge has to do, which would include 1 Stat 23, because it's a constitutional provision to take an oath that satisfies the 6th article of the Constitution. And 1 Stat 23 is a decisional law that said this is the oath that satisfies that. It's been codified now into 4 U.S.C. 101, which is a statute, which, said the same thing. So this is easier for us just to say, well, if you're a state judge, you have to have done this. If you didn't do this, you can't exercise the powers of your office. So none of your judgments have any authority. And that, they have to cause a record or certificate to be made. If the judge doesn't have it, it's not our fault, it's his fault. He has to have it. She has to have it. We have to make sure they have it. And that's what the ruler needs to do. If the ruler finds out they don't, well, the ruler can call in the sword. Okay, but back to the fact that, the thing that they say they're following is called a canon. Now, the Roman Catholic Church has the Code of Canons, but that isn't what we're talking about. That's a whole set of laws for the Catholic Church. Code of Canon Law in 1983, but that isn't these. These are, the rules written for Ohio. But what is a canon? Well, according to Bouvier's Law Dictionary, a canon is from ecclesiastic law. This word is taken from the Greek. It signifies a rule or a law. In ecclesiastic law, it also designates an order of religious persons. Well, we're not talking about them. And whoever Francis is says that the reason why the ecclesiastic call the rules they established as canon or rules and not laws was modesty. They did not dare to call them laws, lest they should seem to arrogate to themselves the authority of princes and magistrates. Right? So they call them canons because they are subordinate to magistrates. I'm saying that a pastor with a gold fringed flag is a magistrate of the Gold Fringed Flag jurisdiction, working for the king, right? He's the king local. He's the magistrate. We're the princes. They're the magistrates, the patriotic pastors, and the patriotic pastors rule over the judges who are under this form of canon law. It's ecclesiastic. So now we're back to, it's in a form of law that a pastor is qualified to judge in because it's a matter of faith. So, okay, hey, it's been 70 minutes. That's long enough. I hope you're still here watching. And if you're a pastor, especially, please watch this again and contact me or contact whoever contacted you to contact me. But what we're going to do next in Ohio is see if we can get this pastor to come do something on behalf of Jerry. And at first it was going to be, well, let's do a sworn statement form with Jerry. But, after having looked at the things I had looked at and just did this video on, that really what the pastor should do is pick up the phone and call Chris. And say, Chris, if you ain't got oath to office, we got a problem here. You're going to have to come explain to me what's going on. And we unravel this Gordian knot of bullshit that's happening so that Jerry can go home. Because he's not being charged for felony. It never really happened. Whatever it is the minor misdemeanor down in the local municipal court. Right? That didn't get transferred over. I'll show you that is one last time. We'll call that good. Right? So if you're in Ohio, this applies to anybody in Ohio. Right? So let's just start there. If you got somebody who's in jail on a felony, this applies to you. Don't call me and ask me how to fix it. Right? I don't know how. I'm pointing out what it is and trying to get it fixed. If I ever get it fixed, I'll do a video on it. But you should understand this applies to you too. And if you know somebody who's a pastor with a gold fringed flag, even if he doesn't know he has one yet, you should go talk to him and make sure he watches this video. But under these rules, we got this initial appearance, preliminary hearing. And if we go down to this preliminary hearing, a felony case, which is what's going on with Jerry, it says, except upon good cause shown, any misdemeanor, other than a minor misdemeanor, arising from the same act or transaction involving a felony, shall be bound over or transferred with the felony case. Well, the reason it's a minor misdemeanor is because it doesn't have any statute number involved. Right? I mean, this one here is a felony statute, but they also have misdemeanor statutes. And because it doesn't have one, then it must be a minor, disturbing the peace and dignity of the state of Ohio. And I'm just believing that down in the municipal court is, where this thing started at. And there's something down there still that has to be taken care of. Right? It's happening in this court, Medina Municipal Court. This isn't the state court of common pleas. This is a municipal court where they're supposed to have the preliminary hearing. And then based on what we're reading here, that too many things open here, jeepers. Right? Except upon good cause shown, any misdemeanor other than a minor misdemeanor arising out of the same act or transaction of felony shall be bound over or transferred to the felony case. Well, that means the minor one's not going to. It's still at the local court. And then, the one that really kills it is this one down here, that a municipal or county court retains jurisdiction on a felony case following a preliminary hearing or waiver thereof until such time as a transcript of the appearance, docket entries, and other matters required for transmittal are filed with the clerk of the court in which the defendant is to appear. Well, they didn't file them in the court that Jerry's in. Hang on, it's right here somewhere. Right? It didn't get filed here, so apparently he's supposed to be in some other court. Because right here. Transcript from Medina Municipal Court. There's the case number and there's no document. It has not been filed on the docket. So the lower court still has jurisdiction. Even though they may think that they don't have jurisdiction anymore. Okay, so that's what we're working on. And we're going to try to get, one of these guys. A patriotic pastor. And say, brother, you're a Romans chapter 13 ruler. If they don't listen to you, you can, call out the sword. Because you got the gold fringed flag. Okay, I'll leave it there. Everybody have a great day, and I'll let you know how it goes. See ya.